to the application filed in the registry of the court on 10 April 2020, whereby the government of the state of Araja instituted proceedings against the public of Ranavo with regard to a dispute concerning alleged violations of international law by Ranavo and in accordance with Article 48 of the Statute of the Court and to Articles 31, 44, 45, Clause 1, 48, and 49 of the Rules of Court of the International Court of Justice. The parties hereby submit to this court. Araja and Ronavo have appointed their respective agents. And now, I would like to invite our first agent in the Araja team, Team 005, to start with Team's short introduction and then proceed with your submission. Good luck, team. Your time starts now.
Good morning, Your Excellencies. May it please the court. I am Carmen. I'm appearing alongside my co-agent in this case, Ms. Divya. We have the honor to appear on behalf of the applicants in this case, the State of Arasia, and my learned agents for the respondents, the Republic of Ronaval, Mr. Martin, and Mr. Kishan. I will submit first for 15 minutes, and Ms. Divya will submit another 15 minutes, and we reserve 5 minutes for rebuttal. Your Excellencies, I will be submitting that the St. Pierre Island belongs to Arasia and that Imaro can intervene in the case between Arasia and Ronaval. Ms. Divya will demonstrate that Arasia is not liable to compensate the respondents for the damage suffered by the HMS Gong Hippo and the HMS Gong Genie. Before I begin with my submissions, would Your Excellencies like a summary of the facts?
I don't think I need to be briefed about the facts. I'm quite familiar with the facts. How about my learned colleague?
Yes, can proceed with the submission.
Yeah, can proceed with the submission.
Much obliged. I will now begin with my submissions proper. The applicants would first like to submit that the St. Pierre Island belongs to Arasia. We submit two bases for this. First, that the St. Pierre Island legally belongs to Arasia pursuant to the United Nations Convention on the Law of the Sea. Article 3 of the United Nations Convention on the Law of the Sea regarding the breadth of the territorial sea states that every state has the right to establish the breadth of its territorial sea up to a limit not exceeding 12 nautical miles, measured from baselines determined in accordance with this convention. If I may, I would like to request for your attention to refer to the Moot problem, page 7. Paragraph 6, line 3. Here it states that the St. Pierre Island belonged to Arasia. It is a fact that has been agreed upon by both parties. Arasia is a state which is a party to the United Nations Convention of the Law of the Sea, and so is Ronaval, and both parties are bound by it. Thus, Arasia has the right to establish that its territorial sea is within the limit of 12 nautical miles.
Council, you mentioned just now that the island is located 12 nautical miles within Arasia, isn't it? So does that mean if the island is located in the territorial sea of a country, automatically it belongs to that particular country because of its location?
Thank you very much for your question, Your Excellency. Yes, pursuant to the United Nations Convention of the Law of the Sea, a state does have the right to establish that its territorial sea is within the limit of 12 nautical miles. Because this island is located within 12 nautical miles of Arasia, it is by right, according to this convention, that Arasia does belong to, the island does belong to Arasia.
But if you look at Pulau Batu Putih, isn't it? The location of Pulau Batu Putih is closer to Johor compared to Singapore, if I'm not mistaken. But still, the court decided in favor of Singapore, isn't it?
I apologize, Your Excellency. Unfortunately, that case is influenced by other factors as well, not only the location of the island, which is why this will be my first basis for this submission.
So we don't have to look at the location of the island only, isn't it? It is not a determining factor.
Yes, our government agrees that this is a very important factor that should be taken into account, but it is not the only determining factor.
All right. Is there any other evidence to substantiate Arias's claim that the St. Pierre Island belongs to Arasia?
Yes, this will be my second basis for the submission, and that is, as Ronoval is the respondent, are the ones who have made the implication of the claim over this island. They have the burden of proof that St. Pierre Island belongs to the respondent. In the case of Cambodia and Thailand concerning the Temple of Preah Vihear in 1962, it is stated that the burden of proof in respect of the facts and contentions on which the respective claims of the parties are based will, of course, lie on the party asserting or putting them forward. So the establishment of a lighthouse and a helipad cannot be considered as having performed acts of a sovereign nature over the St. Pierre Island as well, as Ronoval claimed to have administered the island through the establishment of these navigational aids. However, when we refer to the case concerning sovereignty over Pulau Ligatan and Pulau Simpadan in Indonesia and Malaysia, the court observed that the construction and operation of lighthouses and navigational aids are not normally considered manifestations of state authority.
But if you look at Pulau Batu Putih case, the court held that since the lighthouse has been maintained by Singapore for a very long time without any objection by Malaysia, then Pulau Batu Putih belongs to Singapore. How do you react to that?
Yes, thank you very much, Your Excellency. Which is why in this case, it is also, in the same case that I was referring to, is also referred to the judgment on another case concerning the maritime delimitation and territorial questions between Qatar and Bahrain, which stated that the construction of navigational aids can be legally relevant in the case of very small islands. However, St. Pierre Island is not defined as a very small island. Nowhere in the Moot problem is it stated it is not a fact that St. Pierre Island is a very small island. Thus, the construction of a lighthouse and a helipad by Ronoval cannot be taken into account as legally relevant or as having performed acts of a sovereign nature.
Right. How about the fact that if you look at the map of the state of Arasia, if you look at paragraph 8, the president said that according to the map, the island had been located in the territory of Arasia, isn't it? So can a map be used as a cogent evidence to say that the island belongs to Arasia?
Yes, our government firmly supports our cartographer, which has clearly delineated the boundary of both countries. So it is one of the factors that supports our stand that yes, St. Pierre Island does in fact belong to AirAsia.
Right. So what's your authority for asserting that a map can be used as an evidence to support claims by Arasia?
I apologize, Your Excellencies, because I believe I'm tight on time. I will not be able to assist you on that matter. However,
you can proceed, right?
Yes. So, in conclusion, on behalf of AirAsia, the applicants respectfully request the court to adjudge and declare that the sovereignty of St. Pierre Island belongs to AirAsia. Okay. The next submission of the applicants is that Imaro can intervene in the ICJ proceedings involving AirAsia and Ronoval. Imaro has the legal right to intervene in the ICJ proceedings between both parties pursuant to the statute of the court. Article 62 of the Statute of the Court provides 1. Should a state consider that it has interest of a legal nature which may be affected by the decisions in this case, it may submit a request to the court to be permitted to intervene. And 2, it shall be for the court to decide upon this request. As Imaru claims that its fishermen have been fishing around the island for centuries, it has an interest of legal nature regarding the sovereignty of the St. Pierre Island. Imaru will be affected by the decision in this case. Hence, Imaru does have the right.
So for the purpose of this argument, right, when you're referring to Article 62 of ICJ, such of ICJ for intervention, what is, like, do you have any references, case support of proving that there is an interest of legal nature, particularly for Imaru?
Yes, okay. Can we refer? So I would like to direct your attention to the Moot problem, page 8, paragraph 9. Here it states that Imaru, a neighboring state of both parties, issued a public statement on its government website, which states that neither AirAsia nor Ronaval was right. The area has been consistently claimed by our country. Our fishermen have been fishing around the island for centuries, and there were no objections from any countries regarding this practice. Because it directly affects the life of the fishermen of Imaru, so they do actually have an interest of legal nature regarding the sovereignty of this island. They have an interest regarding the decision of the case.
How can you relate the decision? It's on the sovereignty, sort of like, power to exercise jurisdiction on the island by either applicant or the respondent. And because so long as the claims, the legal interest is not on the sovereignty on the island, could you please elaborate a little bit more on how it would be directly affecting the legal interest of Imaru?
Okay, because as of right now, the St. Pierre Island is still in a very vague area, because there is no definite, because yes, as this case between both parties, there is no definite party that's able to claim 100% that the island is ours of either party, which is why Imaru is able to intervene halfway and say that publish their own statement on their website that says that they refuse to accept any definite claim of ownership over the area. If the case and the proceeding if the case is decided that the island belongs to our client, AirAsia, Imaru cannot say this anymore, which is why they do have an interest of legal nature over this case.
Would there be any relevant facts and situations like Pulau and litigant, because Philippines also apply for intervention in that case?
Yes, Your Excellency, you're absolutely right. Because in that case, Philippines also applied Article 62 of the statute of the court to intervene in that case, because even for them, they also have an interest of legal nature, which is why they are able to apply. And it will be completely up to the court to decide upon the request. But our stance, AirAsia, we do acknowledge that Imaru does have the right to intervene in the proceedings involving both parties.
Counsel, I'm a bit confused right now concerning the legal interest pursued by Imaru. I think they are pursuing sovereignty over the island, isn't it? Not solely claiming that they have fishing rights.
Yes, Your Excellency, you are correct. However, it is our stance as AirAsia to acknowledge that they can intervene in the proceedings. And the judgment upon that will be up to the court. The court will be deciding upon the request. However, our stance is that Imaru they do have the right to apply for an intervention in the case.
All right, okay. Proceed.
All right. Thank you very much, Your Excellencies. If I can be of no further assistance to the court, my co-agent, Ms. Divya, will proceed with her submission.
All right.
Thank you, Ms. Carmen. Yours Excellencies, moving on to my third point, that is Russia is exempt from responsibility for providing renewable damages for the HMS Gong Hippo and compensation for the loss of ship. Under the international humanitarian law and international law and conduct of military operations, Russia will not be liable to compensate renewable for the damages suffered by HMS Gong Hippo. International humanitarian law mentioned that jus in bello regulates the conduct of forces when engaged in war or armed conflict. It is distinct.
There is a situation of armed conflict, isn't it?
Yes.
So when the armed conflict started?
Your Excellency, please to refer to the Moot problem, page 7, paragraph 5, where the president mentioned that President Harris then he ordered 3 nuclear-powered submarines and 4 aircraft carriers to relocate the Barents Sea.
So you're saying that the armed conflict started when the 3 nuclear-powered submarines had been relocated to the Barents Sea, isn't it?
Yes.
But at this particular point of time, there was no act of hostility yet, isn't it? There's no exchange of fires.
Yes. Yes.
So what is the threshold in order for the law of armed conflict to be applied?
I couldn't. Can you repeat the question again?
Yeah, because here he only ordered for the relocation of the nuclear-powered submarines to the Barents Sea, isn't it? So there's no evidence to suggest that he had. There were exchanges of fires between Arasia and Novano.
Yes.
Ronavo, sorry. Yeah.
Yes. So this situation put President Amara to the field of safety of his nation because war is prohibited and threatening a country against the safety is prohibited also.
All right, okay. But the thing is, in order to apply the law of armed conflict, we need to see whether the threshold has been satisfied or not, in order for the armed conflict to arise. But if I'm not seeing any exchanges of fires, can we still apply the law of armed conflict?
Sorry, Excellency, I because I couldn't able to assist with that. We are not sure regarding that also.
All right, so proceed. It's okay, proceed.
So this is what is prohibited, and the threat or use of force against other states is also prohibited, which meant the threat is also prohibited against other states. So war has been seen as an unacceptable means that resolving interstate disputes. As a result, threatening a nation with a military strike is against the law of humanitarian.
All right, okay. So here we are talking about the attack on Gong Hippo, isn't it?
Yes.
So this is because of the laying of mines in the territorial water of Arasia.
Yes.
All right, okay. Okay, so you're saying that the law of armed conflict applied here.
The law of it revokes the law of humanitarian.
Okay, proceed. Okay.
Okay.
So let's talk about the laying of mine itself. Is it prohibited under international law for a state to lay mines in its territorial water?
Okay. In the perspective of United Nations Convention of the Law of Sea, hitting a naval mine and demanding full responsibility is not right, because sovereign waters and international waters, since all the ships of nations enjoy the right of innocent passage through the territorial sea only, and A coastal state is entitled to suspend universal passage to the protect of its national security and for weapons exercises, but in such circumstances, the suspensions must be temporary and only specified areas of its territorial sea. In other words, the right to do so is exceptional. If a coastal state lays armed mines in its territorial waters and fails to give any warning or notification to vessels of another state that have rights of access or the passage, it will be in a breach of its international legal obligation. Yours Excellency, please refer to the Moot problem, page 7, paragraph 5,
Yeah.
which is
So,
stated that
can I ask you one question? What is your authority for saying that a state can lay mines in its territorial water? But there is an obligation to inform the other states about the presence of mines. What is your authority?
under United Nations Convention of the Law of the Sea.
Which provision?
So, I'm not clear about that. Wait.
So
Sorry,
this
Your
is
Excellency, I couldn't able to.
Yeah, so this is concerning the principle of maritime communication, isn't it? So you have the duty to inform the presence of mines in your territorial water.
Yes, and we did inform them also.
So which facts can you refer to the seminal facts? You mentioned that this has been informed, isn't it?
Yes, madam.
Can you,
According to page 7 and paragraph 5.
page 7, paragraph 5.
Yes.
Page 7, paragraph 5. Okay.
So Arasha claimed that the ship had encroached into its territorial waters. And after consistent warning given out by National Coast Guard, HMS Kong Hippo failed to pay the heat but continues its stay in the area.
But if
So
they
the
are exercising the right of innocent passage, then how can you say that they have encroached your territorial water? They are entitled to the right of innocent passage, isn't it? So we cannot say that they have encroached into your territorial water unless the passage is not innocent.
because Republic of Renewal also wasn't sure that Barents Sea was not regarded as high sea. So since Barents Sea is not regarded as high seas, that means intrusion of territorial intrusion of innocent is like happened.
I
So they
see.
entered territorial waters of Russia.
But if you look at the Kofu Channel case, in that case, the court said that the right of innocent passage can also be exercised by warship, isn't it?
I'm not sure regarding that, madam.
All right.
My questions, I have one question. For lane of miles, right? What is your authority actually? How do you justify that? Because, is it because of armed conflict going on, right? Ongoing armed conflict, or would it be considered as the peacetime lane of miles during the peacetime? Because the situations could be different to justify that, because territorial sea, foreign ships can pass through, they have the innocent passage, right? And the and clause. So if you lay naval miles there, you must justify for that, why you do that. So exactly what you refer to, your authority for that, to support, to justify laying of miles.
So the legal authority that we are referring is to passage is innocent so long as it does not adverse to the peace, good order, or security of the coastal area. And it is also stated that Arasha given consistent warning to the National Guards of HMS Kong Hippo, but they failed to hear it. So that's why naval mines were placed.
Why the warning was given in the first place?
Sorry, I couldn't able to hear you, madam.
Why the warning was given in the first place?
Because because HMS Gong Hippo will fail to pay heed when it encroaches the territorial seas.
All right, okay. So by not heeding the warning, has they committed any violation of international law? Or can we say that due to their failure to heed to the warning, it amounts to the right of innocent passage is no longer considered as innocent because of their failure to heed to the warning? Is that your argument?
Yes, madam.
Yeah,
We are saying that passage of innocent is not applicable for them.
because they did not heed the warning.
Yes.
What's your authority?
The authority is passage of innocent, madam, under United Nations Convention Law of the Sea.
All right, okay. Just because they did not heed your warning, is it justifiable for you to lay mines in order to stop them? Is this a proportionate reaction on the part of Arasia?
We planted the mines as a security reason because firstly, Barents Sea is not considered as high seas. So it is territorial waters of Arasia.
All right.
Okay. So the question is it justifiable even if you're territorial sea and you exercise absolute sovereignty, right? The questions what I was asking is it justifiable to lay naval mines in your territorial sea? Because foreign ships are always passing through your territorial sea, exercising the right of innocent passage. So how would you argue that? Yeah. Just to justify the lane of mice, because when they entered, Hippo entered, the mice are already there, right? And Russia was trying to remind them, don't leave the place, and they didn't listen. And at the end of the day, they collided and exploded, and their vessel was sunk, right? Correct.
Yes.
The mice are already there, so that you have to justify that, and to argue that they violate. Comply with the right of innocent passage, you have to prove, is there any violation of your coastal state laws and regulations by run over vessel Hippo? So we are asking on that. Yeah, how to what would be
okay. So as for the innocent passage must be swift and continuous. But so passage is also involves stopping and anchoring, but only in so far those actions are incidental to routine navigation required by force majeure or distress. So to taken 8 people, ships, and aircraft that are in danger or in distress. So this means that HMS Kong Hippo wasn't on innocent of the passage.
Okay. And another question still on this, would there be do your country has any requirements, because Hippo is considered a naval ship or government ship, when they enter the territorial sea, do they need a prior authorization before they enter? Does your country has any requirements for that?
Just following the authority of innocent passage and law of the sea, madam. There are not particular requirements.
Okay. Maybe we can proceed if you have one more, right? Okay, 5 minutes left. How many more issues to cover? One more, right?
Yeah, just one. So therefore, Republic of Renewal is not accountable for claiming that it accidentally hit mines that were set up for security purposes. Your Excellency, I will now move on to my fourth issues, which is that Russia is not liable to compensate Renewal for the damages inflicted to HMS Gongjini. There are currently 2 administrative regions in Russia. One is under President Amara, which is in charge of SUB, and another one is under Aman United, a paramilitary organization. So the group of administration of President Amara frequently engage in intermittent acts of violence against one another, particularly near borders separating the 2 regions. So the following actions, though not all of them, are considered acts of aggression under UN General Assembly resolution, regardless of whether declaration of war.
So we have 2 governments, isn't it? in the state of
Yes,
Arabia. So we have the government led by the President Amara, and the other one which was led by the armed group, which was involved in this question. So which one should be considered as the government of Arasia? Which one has been given acknowledgement by the international community for the purpose of entering into international relations?
So for this government, it is known as like de facto. De facto. They are practicing de facto. So in de facto, there are two territories, but let me add, and they are supposed to follow de jure, means expressed by law, and a de facto standard is a dominant position by tradition and enforcement of market dominance. So it is not necessary receive formal approval for the way of standardization process.
Okay, so the main issue here is about the attribution of conduct, isn't it? Can
Yes.
the act committed by the armed group attributed to the government of Arasia? Isn't it?
Yes.
All right, okay. So you're saying that no.
Yeah, no.
Why do you say so?
Because it was conducted by a paramilitary organization, which is known as AMAN. That
You
is,
mentioned just now they are also in control of one part of the territory of Arasia, isn't it?
it is one part of, but that is considered as another administrative regions.
Yes, but in the absence of a legitimate government representing both part of the territories, then we can say that any act committed by the paramilitary group can be attributed to the government of Arasia, isn't it? Or can be attributed to Arasia, because they are also in control of a particular part of the territory, isn't it?
We just know the two administrative regions are known as region, but conducts of paramilitary organization of Amen United is not, we are not, Russia is not liable of that.
Why? Why do you say so?
Sorry, Your Excellency, I don't have a particular law to support the statement.
All right, okay, you can proceed with your submission. Yeah, proceed.
So it is known as there are three criteria for the act of aggression, which is it must be perpetrated by state and can engage responsibility for such state, and it must imply use of armed force, and it must reach level of sufficient gravity in order to qualify such by Security Council. Thus, the paramilitary organization Amen attack is not liable by Russia's, or Russia is not responsible for the attack. For the foregoing reason, I respectfully request
Would
the
it
court.
be, sorry, would it be the same like, China? And is it Hong Kong, or I always confuse Hong Kong and, it's still China, at international level, China does not recognize that, it's a different country, right? Sovereign, it's a very sovereign country. Would it be the same? Or if you argue that because it is just the paramilitary or consider rebellions, what they consider, the president consider them as, they are just a private and rebellions, and it has no control over them. But even if you argue that, would these Eurasia be responsible for any kind of, failure to exercise due diligence? Is that possible? They didn't protect it, or it's just they have the separate authority? Is it considered as two separate country, or can it be still considered as the same country, but there is a rebellion controlling the part of the territory?
It's considered as same nation, but there is which is authorized by two administrative. So let me explain it further. So like under the de facto boundaries, the area that is government is actually able to enforce its law. That means that Russia and paramilitary has two different laws, and It is against endorsement by other countries that may also claim the same territory de jure.
That's all right.
Yeah, that's all from me.
Okay, so rebuttal.
I think we need to hear from the respondent, isn't it?
Oh, rebuttal comes later. Oh, sorry.
Yeah, rebuttal comes later, yes. Yeah, counsel for the first respondent, you can proceed.
Am I audible, judges?
Yes. Yes.
Right. Mr. President, Your Excellency, may it please this court. My name is Kishan Kumar, and I appear for the respondent, Republic of Ronavol, along with my co-agent, Martin Liu. I will be speaking first for 17 minutes, and my co-agent will speak second for 17 minutes, and we reserve 1 minute for rebuttal. Today, the respondent has 4 submissions to make, in which I will deal with the first and second issue, while my co-agent will deal with the third and fourth issue. First issue is whether the Senpei Island belongs to Arsia or Runawol. Second issue is whether Imaru can intervene in the ICJ proceedings involving Arsia and Runawol. Third and the last issue is whether Arsia is liable to compensate our government for the damage suffered by our naval ship, namely HMS Kong Kipo and HMS Kong Ginny. Unless there is any preliminary question, I will now begin with my submissions proper. Your Excellency, we submit that the Senpei Island belongs to our government because our government has acquired the island through prescription for 2 grounds. First, possession of our government has actual exercise of sovereignty over the Senpei Island. Second, possession of our government is peaceful and uninterrupted. Turning to our first ground of the first issue, Your Excellency, possession of our government has actual exercise of sovereignty because there is an intention to act as sovereign by our government on the Senpei Island. Your Excellency, in Clipperton Island case in 1931 and Eastern Greenland case in 1933, this court emphasized that an actual display of sovereignty must be accompanied by an intention to act as sovereign.
Counsel, if you look at the mood problem in page 7, paragraph 6, the Saint Pierre Island belong to Arasia, isn't it?
Yes, Your Excellency.
All right. So, since the original title of the island, it belongs to Arasia, then can prescription defeats the title of a state who has the original ownership over that territory?
But Your Excellency, besides the fishing customary rights that established by the applicant, there are no any other activities that intended by the applicant to act as sovereign on the island, Your Excellency.
So I understand your argument, but the thing is, since it is their territory, originally it belongs to them, then there's no need for them to display any sovereignty over that territory, just to show to the other countries that, they have rights over this territory.
Your Excellency, we have established the lighthouse and a helipad on the island, and we have maintaining the helipad and lighthouses for 53 years, for the last 53 years, and there were no any protests from the applicant saying that it's their island.
But I think the facts of the case, it does not mention whether Arasa has made any protest or has not made any protest, isn't it? Arasa claimed that such establishment was by no means a relinquishment of its sovereign right over the island, right? So it shows that by making such statement, Arasia has not relinquished its rights over the island.
But Your Excellency, in Temple of Priya Vaihar case in 1992, the Thailand had acquiesced for many years by failing to object to a map that had been drawn by Mixed Commission in 1980, showing the temple as being on the Cambodian side of the border, and Thailand was thus stopped from denying the fact which was established by the map. Your Excellency, what I'm trying to submit is that the applicant's cartographer itself delineated the boundary between Ronavol and Aresia, but even the applicant's cartographer delineated the boundary, they, as the former sovereign, has failed to protest against some government's administration over the Sanpe Island for the last 53 years. So the absence of protest by
my concern with your argument is that there's no suggestion that they have not made any protest, isn't it? In
yes,
fact,
Your Excellency, but there is no. Yes, Your Excellency.
So can we say that Ronavo right now had constructed the lighthouse on the island and building the helipad, and these are illegals? They had encroached the territory of Arasia by doing so.
But Your Excellency, it's the lighthouse. The existence of the lighthouse and the helipad is on the island for the 53 years. And it is the direct acquiescence given by the applicant to give up its sovereign right over the island, Your Excellency.
Yeah, but the lighthouse can be maintained by other government, but it does not necessarily mean that the land itself belongs to the government who had maintained the lighthouse, isn't it?
Your Excellency, in Camisel arbitration in 1963, the claim by US claiming the Mexican territory failed as Mexico had made a number of protests to the US, as a result of which a convention had been signed in an attempt to settle the rights of the two nations. Thus, the diplomatic protests by Mexico prevented title arising by prescription. Your Excellency, the Applicant's Act is contrary to the Mexico's Act because Mexico has established protests against the US for claiming the title by prescription. And for applicant, they didn't even protest against our administration over the island, Your Excellency.
But by claiming that, by allowing the lighthouse to be maintained by Ronavo, it does not necessarily mean that they are willing to relinquish their sovereignty, isn't it? So can that be considered as a protest? Can we say that this protest is, this statement is sufficient as an evidence to say that this is a protest?
No, Your Excellency, could you rephrase the question?
Yeah, I understand your argument just now. Here in this situation, the RSN need to protest, isn't it?
Yeah.
But here, when they state that, or when they claim that, even if they allowed the lighthouse to be maintained by Novano, it does not necessarily mean that they are willing to relinquish their rights over the island, isn't it? So this statement, can we consider that this is a form of protest? When we invoke this statement, at least we can show that the sovereignty alleged to be, to be argued by Novano, at least it cannot be considered as peaceful or uninterrupted when we apply the prescription principle.
Your Excellency, the sovereign activities by our government at least has a more reasonable sovereign activities than the applicant because there are no sovereign activities on the Sanpe Island, Your Excellency. Because they only allege the fishing practice, Your Excellency. Well, according to the Article 38 of the International Court of Justice Statute, it is considered as the authority formulation, the formal sources of international law, wherein customary international law is defined as evidence of a general practice accepted as law, Your Excellency. There's no evidence that this is a continuous general practice by the applicant, Your Excellency.
All right, okay, proceed.
Your Excellency, I will now move to our second submission that IMARO cannot intervene in the ICJ proceedings involving Arasia and Ronavo because IMARO has not established the existence of an interest of a legal nature justifying the intervention. In the judgments concerning the applications for permission to intervene submitted respectively by Honduras and Costa Rica in 2010, the court clarified that under Article 62, the state seeking to intervene as a non-party does not have to establish that one of its rights may be affected. It is sufficient for the state to prove that its interests of legal nature may be affected. Similarly, Imaro seeking to intervene has only established that its fishing rights may be affected. Fishing rights is of a general interest.
But if you look at the statement of facts, they are claiming that they have ownership over the island, and one of the evidence to support their claim is the fact that their fishermen had conducted fishing activities on the island for centuries. So this is, sufficient to show that they have actually a legal interest to intervene in this case.
But your Excellency, it is emphasized in territorial and maritime dispute in application by Honduras for permission to intervene that the legal interest is defined by the court as a real and concrete claim of the state seeking to intervene and also based on law. And according to Judge at Hogaja, the interest of legal nature must exist according to the international law. Your Excellency, we submit that there were no any agreements between our government and the applicant saying the fishing rights has existed as a custom, Your Excellency.
But there's no need for an agreement in order to show that there is a customary international law, isn't it? So this is the two separate things.
Yeah, Your Excellency, but they have the burden of proof to prove that the existence of the custom practice is a consistent and a uniform practice among the applicant.
Yeah, that is why they need to intervene in the proceeding so that the court can hear their argument why they say that they have rights under customary international law. So that is sufficient to establish legal interest, right?
But Your Excellency, Imaro, sorry, Excellency. Could you rephrase the question, Your Excellency?
You mentioned just now that they claim that they have rights under customary international law to conduct fishing activities on the island. And despite the absence of the agreement between Ronavol and Imaro about this, Imaro right now is claiming under customary international law, right? So there's no need for an agreement to be shown, a written agreement, as long as Imaro can show that there is customary international law, isn't it? So that is why Imaro need to be, we need to consider Imaro's claim to intervene in the proceedings so that they can establish their legal interest.
Yes, Your Excellency. Your Excellency, the custom, if it's a custom practice, Your Excellency,
yeah,
the international law should have recognized it, and every state should have known about this. Should have known about this practice, Your Excellency.
Right.
But
okay, so can we say that if someone is fishing, a country is fishing in a certain area for centuries, so would that be sufficient to claim the nearest island or the territories to have, to claim sovereignty over that particular territory, only because of the reason that, that would be not so relevant for your argument, yeah? So, so, okay, maybe my question is not so relevant to your point here. You are arguing on, I was thinking something else. You are arguing on IMRO cannot intervene, yeah? So you are saying that it has no legal interest, right? That is your argument. Okay, so can you please just to recap, what would be your main argument for saying that this country does not have legal interest? Because just now there are many facts and explanation, yeah.
Your Excellency, what we're trying to submit is that the fishing rights is not a real and concrete claim of the applicants claiming, of the Imaro of the third state claiming to be, Your Excellency. And, Your Excellency. Your Excellency, it is emphasized in Anglo-Norwegian fisheries case in 1951 that the independent activity of private individuals is of little value unless it can be shown that they have acted in pursuance of a license or some other authority received from their government, Your Excellency. But there is no any evidence that they acted in pursuance of the Imaro's government, Your Excellency.
Okay.
All right, proceed.
The case concerning land and maritime boundary between Cameroon and Nigeria, the court accepted the Equatorial Guinea possessed a legal interest over an area overlapping with that consent by the maritime delimitation forming the object of the main proceedings, and that interest would have been affected by the decision of the court. Your Excellency, without...
Okay. So I do have a question. If you look at the statement of facts in paragraph 9, the Tim Penyu had supported the claim by Imaro, isn't it, to intervene in the ICJ proceeding. And Tim Penyu is responsible to conserve the endangered sea turtles on the island. Can we say that the support given by Tim Penyu, it is a good ground to substantiate claim made by Imaro that they can intervene in the proceeding? At least, perhaps they play an essential role to conserve the endangered sea turtles.
But Your Excellency, in the same paragraph, in the same Moot problem, paragraph 9, the Imaro only claiming the Senpei Island in the basis of their fishing rights for centuries.
But the fishing rights is only to support their claim or to substantiate. It can become as an evidence to substantiate their claim that they have ownership over the island, isn't it?
Yes, yes, yes.
Yeah. So they are not claiming that they have fishing rights. They are claiming that they have ownership of the island. Evidence, this can be seen from the fishing activities conducted by the fishermen. And I think because of the testimony given by Tim Penyu, it seems that now Imaro also was involved in the conservation of endangered sea turtles.
But Your Excellency, the Moot problem is silent about the further evidence of Imaro's claiming to conserve the endangered sea turtles, Your Excellency. There's no evidence.
Yeah.
Imaro claiming.
Sorry, that fact is in the questions?
Yeah.
Which paragraph? Sorry, that
Paragraph 9. Maybe it is not directly, but we say that indirectly it seems that somehow Imaro is involved with the conservation of the sea turtles. So let's say hypothetically Imaro is involved in the conservation of sea turtles. Can that be considered as in argument to support their claim to intervene in the proceeding? Because if you look at Sipadan and Ligitan case, isn't it? The fact that Malaysia has implement legislation to preserve turtles, then it can be considered as an evidence to say that Malaysia has sovereignty over the island.
But Your Excellency, in that case, the party was a party to the case and not a third state. So that the sovereign activities claiming by the party was a party to the case, and Imaro is non-party, as intervening as a non-party, Your Excellency.
Yes, but they need to show that they have legal interest, isn't it?
Yes, Your Excellency.
Right. Okay. We can proceed with the submission. Oh yeah. So we are running out of time.
Oh yeah, Mr. President. Sorry. Madam President, Your Excellency, if I can be of no assistance to this court, my co-agent will proceed with our third and fourth issue.
All right. Okay. Thank you.
May it please this court.
Right.
Before I begin, am I audible to all of you?
Yes.
Yes, Martin.
Good afternoon, Madam President, Your Excellencies. May it please the court. My name is Martin Liu, and I will be assisting this court regarding the third and fourth issues, whether the third regarding whether RSA is liable to compensate Ronawal for the damage suffered by HMS Gong Hippo, and for whether RSA is liable to compensate Ronawal for the damage suffered by HMS Gong Genie. Turning to the third issue, Your Excellencies, we submit that the applicant is liable to compensate Ronawal for the damage suffered by our naval ship, which is the HMS Gong Hippo, for two grounds. Firstly, the HMS Gong Hippo was engaged in innocent passage, and secondly, the applicant's act of planting naval mines is not justified as self-defense. Your Excellencies, HMS Gong Hippo was engaged in innocent passage through Arisia's territorial sea, and the naval ship was on high seas. This is permitted under Article 87 of United Nations Convention's Law of Seas, which states that all states have the right to exercise the freedom of seas, including freedom of navigation. Your Excellencies, in these current circumstances, there is an absence of unlawful activity carried out by our naval ship. Therefore, it is indeed that our naval ship was engaged in innocent passage.
Sorry, Counsel. Are you saying that Hippo is in the high sea, not in territorial sea?
Yes, yes.
But just now you also mentioned about innocent passage. Could you please, clarify on that?
Yes, Your Excellency. Innocent passage meaning is that the ship encroachment does not prejudicial to the coastal state, or does not affect the security of the coastal state, Your Excellencies. And here we would like to submit that our naval ship does not carry any unlawful activities that affected this coastal state, Your Excellencies.
But
Yes,
can the right of, yeah. I think what my learned colleague is asking just now, can the right of innocent passage be exercised on the high seas? Because on the high seas we have complete freedom of navigation, isn't it? So there's no need to invoke the right of innocent passage.
Your Excellencies, may I have a moment, Your Excellencies? We would like to submit that the high seas are open to all states, and therefore it allows the states to freedom of navigation and then freedom of the seas, Your Excellencies. And this has been exercised by our naval ship. Therefore, to constitute that whether it is innocent passage, it should be seen whether the activity was carried out unlawful to the coastal state, Your Excellencies.
So the mines were, planted inside the territorial sea of Russia or high seas?
Your Excellency, can you repeat the question?
Naval mines planted by Russia, right, was in their territorial sea, which is within 12 nautical miles or beyond 12 nautical miles.
My apologies, Your Excellency, because of my earlier explanation. In regard with the question, ARISA does plant their naval mines in their territorial sea because our naval ship was encroaching towards their territorial sea, Your Excellencies.
Oh, mines were planted within their territorial sea, but you are just entering their territorial sea, right?
Yes,
exercising the right of innocent passage. Then freedom of navigation does not apply there. It's two different things, right?
Yes, Your Excellencies. Freedom of navigation is not applied in the territory sea. It is applied in the high seas.
Yes.
According to the Article 19 of United Nations Convention's Law of Seas, passage should be innocent so long it is not prejudicial to the peace. My apologies. Prejudicial to the peace, good order, and security of the coastal state. The non-innocence of passage cannot merely asserted by Arisia. Instead, the presumptions of non-innocence, they should supply the proof of non-innocence in behalf of their side, Your Excellencies. Furthermore, in Corfu Channel, this...
Well, I'm kind of a bit confused. Who has the burden of proof to show that the passage is not innocent?
The burden of proof lies on the applicant, Your Excellencies.
Why you say so?
Because we contend that our narrowship is exercising this innocent passage. If they were to argue that our narrowship was exercising non-innocent passage, they should supply the proof to support their argument, Your Excellencies.
But they actually submitted an evidence in paragraph 5. The ship failed to adhere to the warning given, rendering the passage no longer can be considered as innocent, isn't it?
Your Excellencies, in regard to that, we would like to submit that all ships, including warships, enjoys the right of innocent passage through the territorial sea, and it is in accordance with the international law, for which neither prior notification or authorization is required, Your Excellencies. And also to support our argument, I would like to bring you to the case of Corfu Channel, where the passage is innocent so long it is not prejudicial to the peace, good order, and security of the coastal state. Also, the character of the ship.
If the passage is innocent, then why do you do not comply with the warning? Meaning that you can just comply with the warning and then give them, some statement to say that you're not doing anything in your territory, isn't it?
Apologies, Your Excellencies. However, this is silent in our Moot problem, and therefore I am unable to assist you with this matter, Your Excellencies.
All right, so meaning that under international law, the law of the sea, it is okay for the warning to be ignored.
We are not submitting that. However, we contend that such if we were to trespass their coastal state, we do not need to notify them of our existence in their territorial sea.
Is it necessary? Is it necessary for the warships, right? Warships of foreign country, if they want to enter the territorial sea of a coastal state, is it compulsory and the law of the sea that you have to notify the authorities?
No, Excellency, we do not submit that.
Okay. Okay.
All right. Moving on to our second ground, Your Excellencies. The ILSA Act of planting naval mines is not justified by self-defense because first, there is no armed attack occurred, and second, the failure to immediately notify the Security Council stops ILSA from claiming that the act of planting naval mines is justified as self-defense. Your Excellencies, the exercise of right of self-defense is subject to a state having been...
The applicant submitted just now that a state can lay mines in its territorial water as long as it gives notification to other states about the presence of the mines, isn't it? So there's no need for armed attack to happen first in order for them to lay mines in their territorial water. It is their sovereign rights.
However, Your Excellencies, we like to submit that it should be necessary and proportional to the attack occurred. However, in these current circumstances, there is no attack occurred in this current case. Your Excellencies, armed attacks are classified as the greatest use of force and must be distinguished from other lesser use of force. In oil platform, the court found that the series of minor attacks was not sufficient to justification for self-defense. In this current case, ILSA suffered no armed attack, which will not give rise to the right of self-defense. Moving on to our second point, Article 51 of the United Nations Charter requires states that use force in self-defense to immediately notify the Security Council.
Sorry, Council. You are talking about self-defense and Article 51 for this laying of mines in its own territorial waters. What is the relevance there? because this is their territorial water and they have the sovereignty, they technically exercise full sovereignty, except for one exception, which is the right of innocent passage, right? So what is the relevance of, just now you say, self-defense and armed attack? Is that necessary?
Your Excellencies, the planting of naval mines has resulted in severe damage and losses of lives. Therefore, such act is not proportionate and necessity. I would like to bring you attention to the case of Caroline case, where there's the ship from British has been captured and destroyed. Therefore, my apologies, ships from United States has been captured and destroyed by the British Army. And there's two key points that have been laid out from this case, which is the necessity and proportionality. Necessity means that the threat should...
Sorry, Counsel. Are you talking about Hippo or Genie? Which ships you are talking about?
We are submitting regarding the HMS Gong Hippo.
Hippo, right? So why you are talking about proportionality and all? Is there already armed attack based on this point? Armed attack between the two countries, Russia and Russia, or it's just only the innocent passage? You are just exercising your right of innocent passage, and you collided with their naval mines.
Your Excellency, we would like to submit that there is no armed attack occurred. If they were to lay down their naval mines, they should have seen the threat first, then they are able to use of force. However, in this current case, there is no armed attack occurred and there's no threat of force were being used by our government.
But they are laying mines in their own territorial water, isn't it? So that is our question.
We want to hear your argument, how to respond to that.
Your Excellency, I'm unable to assist you regarding the matter, Your Excellency.
It's okay, please proceed.
Right. Your Excellencies, turning to our court issues, ILSA is obligated to make reparation, and ILSA's attack on the HMS Gong Genie was an unlawful use of force amounting to aggression. In regard with the first ground, ILSA is obligated to make reparation because they have committed an international unlawful act, and therefore their injury has caused a product of international wrongful act. Thus, ILSA must make reparation to account for all their illegal consequences, both material and moral. For the second ground, Your Excellencies, ILSA attack on the HMS Gong Genie was an unlawful use of force amounting to aggression. In assessing whether their attack constitute an armed attack.
This is an attack committed by a paramilitary group, isn't it? Right?
Yes, Your Excellencies.
So if, let's say, the paramilitary group is not attributed to the government of Russia, then can we still say that there is an armed attack?
Your Excellencies, we submit that the paramilitary group is attributable to Russia because it is an autocratic country and it is globally known as one nation, where President Amara holds supreme and absolute power, which President Amara is unbounded by the constitutional limit. Even though RSA is divided to different administrative areas, this autocracy government holds that both administrative are under the same country, which is de jure, Your Excellencies. Therefore, it is attributable to RSA, and whether it is a form of aggression, the court should assist.
Which article? Because you also mentioned the draft articles on state responsibility 2001. Which article would you apply for attribution for this?
Your Excellencies, this conduct directly and controlled by a state, and therefore it is under Article 8, Your Excellencies.
Article 8. Article 8 has two parts, like if you divide, right? Is they give they added under the instructions of the government, which is supposed to be the government of Russia, right? And the second is there is a connections, there might be different activities, but that particular activities that's attacking Ranovo ships, right? Dini was there is a link between what is the term? Sorry, I couldn't recall. So there is two different situations. So which one you will apply? So you're applying Article 8, but which part of Article 8?
Your Excellencies, my apologies. It is supposed to be Article 5, where the conduct of the person is exercising the elements of government authority. And the elements of government authority here is the autocracy, Your Excellencies.
How? Because in the facts it says that they are paramilitary groups. In fact, they don't see eye to eye. How will they be, following the instructions of this president? What's the name of President
Amara.
Amara, yes.
Your Excellency, it's widely known that even though it is divided into two different administrative areas, the elements of government authority here I would like to bring your attention is that it is the government of autocracy. And if the parliamentary group is exercising its attack without its authority of the President Amara, it sounds bigotry, Your Excellencies. It should be the elements of...
The President of Arasia, Amara, he himself said that the attack, it is not directed by Arasia. Arasia should not be held responsible. So he denied any connection with the paramilitary group.
Your Excellencies, in regard to that matter, I'm unable to assist you. However, we would like to still submit that it is globally known as a country, and even it's known as a country, it should be it has the elements of government, and therefore both of the administrative area should held accountable.
How? I cannot see the points that just now you say Article 8 and now you go for Article 5. Which one you are relying now? Which article? 5 or 8?
Article 5, Your Excellencies.
Article 5. Yes. Article 5, the scope for Article 5 is that the people who are they are not exactly like part of the government or state organs, but there must be some sort of evidence and facts given that they were somehow acting under the instructions or they are serving the government, like something like the maybe the private security companies, protecting the president, maybe like prime minister while they are on trade, something like that. So there must be some kind of official communications, although they are not full-time part of the government service, So how do you link to this paramilitary and this the government, the President Amara government?
To link whether it is attributable to Arasia, we do not have relevant authority to that, Your Excellencies. Therefore, Your Excellencies, may I briefly conclude our government submission?
Yes.
Wait. Now you suggest that even though they have two administration system in a country, but at the end of the day, they are considered as one nation, isn't it?
Yes, Your Excellency.
Having two administrative governments. And under international law, there is no duty on the part of state to recognize government, isn't it? Right. But this is a very challenging situation because you have two different regimes representing a nation. Right. So you are saying that it doesn't really matter which organs of the government perform the act, as long as they are performed by anybody coming from these two administrative system, then it can be attributed to the government, to the state, isn't it? Right. So this is for me unprecedented situation. So do you have any authority to say that it doesn't really matter, right? So at the end of the day, these two administrative systems, they are operating simultaneously in this territory. So whatever thing that they do, it can be attributed to the Arasian government, to Arasia as a state. Any authority on this point?
My apologies, Your Excellencies. I'm unable to provide such authority right now.
Right, okay.
Your Excellencies, therefore, we'd like to declare that, Your Excellency, if there's no further assistance to the court, this concludes the respondent submission. Thank you, Your Excellencies. May it please the court.
All right, thank you very much. Okay. So you can move on to rebuttal.
Your Excellency, I would like to rebut the point of innocent passage. Because HMS Gong Hippo is considered as warship, and Russia claimed that there were consistent warning given out by the National Coast Guard. So there was a threat. If there was a threat or use of a force against the sovereignty, the innocent passage won't be able to, so that the Russia won't be liable for damages done by damages done to HMS Gong Hippo. And Ronowo wasn't aware of the statement, where the Ronowo also mentioned that Barents Sea is not considered as the high sea, and Russia is considered as an autocratic country. So the system of an autocratic country does not outline the responsibility of Russia and the President Amara. And there is also followed de facto boundaries of the countries, which is known as this area under the government is actually able to enforce its law in and to defend against encroachment by other countries that may also claim the same territory de jure. That's all.
Yeah, proceed.
Your Excellencies, respondent has one point to make in regard with the innocent passage. The applicant has contended that our naval ship was not exercising non-innocent passage. However, because of the threat that we showcase in their coastal sea. However, I would like to bring your attention to the case of Corfu Channel, where it is stated that it is not the character of the ship which determining factor of the threat, but rather the character of the passage itself. Our naval ship is engaged in innocent passage, and it shows that our ship is not in a combating formation. There's no guns employed to the coastal state, and it is not in a armed attack position. Therefore, we still submit that our naval ship is exercising the innocent passage. Therefore, that concludes the rebuttal. May it please the court.
Yes, Aisha?
I think we have come to an end to the session. Both of the team already submitted their rebuttals and rebuttals. Any additional comments or questions from the judges?
Also, we don't need to deliberate, isn't it?
Yeah.
Oh yeah, we just straight away give our comment. All right. So can I start first?
Yes, yes.
All right, okay. So first of all, thank you very much, you guys. You guys did a very good job. So I do have a few comments that I would like to make. So I hope it will improve your performance for the next round. Firstly, for the first oral is for the applicant, Carmen. Right. So good eye contact. For me, personally, I think you have to watch your pacing a bit because it was a bit fast for me. So it is sometimes it is hard for me to follow your argument. Okay, so you need to watch your pacing a bit. I think. Okay, so personally, everybody mentioned mood problem, referring to the mood problem, isn't it? For me personally, I would prefer to use a statement of facts instead of mood problem. So it makes, it does not seem too much like an academic exercise, right? And then I think one thing that you need to improve is your analysis about the argument. So I think you need to have more in-depth analysis about the mood problem, the legal arguments. So I think that would be one of the things you need to improve, right? Okay, so you need to have more analysis, in-depth analysis. Okay, and then for the second oralist, all right. So again, eye contact is good. You have addressed the questions, but the thing is, I think you need to improve your knowledge about the law. Again, you need to have in-depth analysis, more in-depth analysis about the arguments. Okay, but again, I think you have a good composure. So you are able to communicate with the judges. Okay, so I think that would be some of the comment that I have for your performance. Okay, for the counsel for the oralist, okay, first oralist, right? First for the respondent. Okay. Sorry. For the second applicant, I do have one more point about when you do your rebuttal. Okay, so you have to mention how many points do you have for your rebuttal. Okay, I have 3 points. First point is something like that, and then second and third, right? Yeah, okay. And then for the first respondent, for counsel for the first for the respondent, first respondent, again, a good composure, pacing is good, eye contact is quite okay, but I can still sense that you are reading from your script. Okay, and then when you submit, try to comply with the court etiquette. You mentioned just now, so it is so. Okay, and your composure, I think you tend to be a bit hostile when I ask you so many questions. Okay, so try not to be too hostile with the judges. You need to to be a bit more relaxed when we ask you questions, right? We did ask you a lot of questions, so yeah. Okay, and then okay, so let's move on to the last mooter for this session. Okay, so firstly, I think eye contact is a bit lacking. Okay, so I can sense that you are reading from your script, so you need to maintain your eye contact. Okay, so and then you need to familiarize yourself with the law, and then you need to increase your familiarity with the statement of facts. Okay, and then we do have problem with the construction of your argument because, for example, you mentioned about freedom of the sea, high seas, and the territorial sea, isn't it? So maybe you can say that, okay, firstly, under the high seas, there's a breach of the freedom of navigation or something like that. Okay, and then you move on. You talk about the territorial sea. Okay, so just now I think both of us, we were a bit confused about the direction of your argument. So you need to separate them. right, properly. Okay, and then, but I think at the end of the day, I really like your composure. I mean, despite of us bombarding you with a lot of questions, you still maintain your composure, all right? Okay. Okay, and then lastly, in your rebuttal, you mentioned about the ship is exercising the right of innocent passage. It is not pointing guns to anybody, but that is not stated in the fact, isn't it? All right, so you need to stick with the facts. The fact is as it is, so you cannot introduce something new. All right, okay, so that is some of my comments. Okay, thank you very much, guys.
Thank you, Dr. Umi. Dr. Umi covered quite a lot, very detailed, for each of you. So I think you can take note of that. But first of all, yeah, thank you so much for inviting me. In fact, I think Dr. Umi has more experience sitting as a judge. So she's like more, very natural. And I have been just behind the scene. I have been, whenever they have the law of the sea questions, they will approach me. So I have been helping, but I've never, personally sat as a judge. So I was saying that, should I interrupt or not? Then whatever we ask is just, for you to get practice. Please consider it as like a practice section. It's not like we went to condemn you or, it's not like that. So I'm sure you know that, right? So I really appreciate all your effort, right? All of you are third year, right? Third year, I guess. Final.
First year.
First year.
Oh, wow.
Wow. Okay.
Wonderful. You are still a first year and you are handling these kind of questions, very complicated, a law of the sea. And so let's take responsibility. They are very technical areas of international law. So I really, really appreciate and I've been appreciate all your effort, you have been put in. So also for okay, I won't cover what Dr. Umi covered already. Like she covered very detailed on the comments. So yes, I will give a very general comments. It is mainly on the way you carry yourself and you present, and of course based on the facts on the law and the arrangement of your idea, and based on whatever we ask you for this preliminary round, you can fill in all those gaps for the next level also, right? So that if there is any potential questions coming up to you, you are ready to explain, give the answer and respond to them. So and also for comment, right? I can only see your face. So if this is the, this still be the online, please try to show at least your until here. You can see the judges can see you. And for I will say more research on each area, right? For each questions, try to have what are the relevant laws, and especially for the applicant part as well, right? For when you keep bringing in, both applicant and respondent, when you talk about arm attack, proportionality, all those are not used in the right place, So, and also if you read the questions, it says that the questions mainly highlighted on law of treaties, and of course the articles on strict responsibilities is pretty much relevant for especially for the last issues, and law of the sea. So whenever you discuss, for example, if you're arguing on island, then you might also refer to Article 21, right, of the law of the sea. So all the relevant authorities has to be there. So when you prepare your memory itself, we have these structures, right? We have to know the issue, apply the law, identify the law, apply the law, and why you say so, right? So that's the reason why all the authorities has to be in order, the laws and the case law. And then you must also have a strong reason and argument that when you particularly mention the case law, why you have to use this case law, how it close the facts are, the situations are, the court reasonings are, So when you do research, just to include those parts, you have a framework already, but just to make it better, right? So I think I will just focus more on that part. But other than that, you all did very well, and thank you so much, and all the best for the next round.
Yeah.
Thank you so much.
Thank you.
Thank you, judges.
Aisha, when shall we submit this, Aisha, the form?
Um, as soon as you can.
As soon as I can. Okay.
Yeah.
So the marks for the memorial, can I submit it later as well? But it is today.
Oh yeah, actually, okay. So I just got information. As soon as the session ends, actually, yeah.
Oh, for this one.
Yep.
All right. Okay. Right. Okay. So I'll submit it as soon as possible.
Thank you. Thank you so much.
All right. Thank you. Bye.
Thank you.
Thank you.
Bye.
Bye.
Take care.
Okay.